Okay.
Hello, and welcome to Tea Time with the Jackson Center. I am Kristan McMahon, and I serve as the president of the Robert H. Jackson Center in Jamestown, New York. Our guest today is Gregory Nevins, senior counsel and the director of Lambda Legal's Employment Fairness Project. Lambda Legal is the nation's oldest and largest national legal organization whose mission is to achieve full recognition of the civil rights of all LGBTQ persons and everyone living with HIV. Greg successfully argued the first two federal appellate cases to rulings that Title VII of the Civil Rights Act of 1964 covers sexual orientation discrimination. And Greg, thank you so much for being with us today.
It's great to be here. Thank you for having me.
Of course. So I think to start, let's probably quickly recap. So prior to this opinion, I believe it was 27 states did not have employment discrimination protections for homosexual or transgender employees.
That is correct. Yeah, I mean, we always say explicit because, of course, we if they prevent sex discrimination, that's the whole thing. But yes, yes, lacking that key component of explicit protections. That's correct. Yeah.
And this came out of three cases that were consolidated together. So the Bostock case, the Zarda case, which I believe you argued in the Second Circuit, right, and then RG and GR Harris Funeral Homes. And so these came out of three different circuits, and the circuits ended up ruling on these differently. So the Supreme Court took it to clear up that confusion.
That's exactly right. Yes.
Great. Okay. So when you and I were talking originally to set this up, I took us back initially to the oral arguments last fall, and that the questions the justices were asking seemed to give some hints as to how they might ultimately play out in this opinion. And you told me that you left the oral arguments fairly convinced that the individuals would succeed against the employers. Could you tell us why?
Sure, because I mean because I mean, and it was very interesting because and the key focus was on Justice Gorsuch. Well, in my mind, going in and coming out of it, but and to the extent that wasn't true for others, I think a lot of people thought the same thing or were converted to that notion during the argument. And what I would say is that when he said certain things that normally would tell you as a textualist justice that he is absolutely in your corner, meaning that he specifically said to the lawyer he was questioning that he agreed with the idea that they had the better of the argument that the employees had the better of the argument on the textualist front, and that nobody was trying to change the meaning of any word from the statute as it was enacted in 1964. And then came the but thing, the part of it which scared a lot of people, which is that what about the massive social upheaval that would happen if we ruled for you? And of course, when you use a term like that, people tend to pay attention, and a lot of people panic. Now, normally for a textualist, they don't worry about the consequences of adhering to the words of the statute because that's the job of the people across the street in Capitol Hill to take care of. So it was very off-brand for him to raise that, but in a sense, but that's why that. I mean, a lot of people are going like, well, gosh, considering he said that, we're in real big trouble. And I was like, no, there's no. Couldn't imagine a universe where he actually said, where he actually agreed with people in the text, but then said, but the consequences are troubling, so therefore I'm not going to go with the text of the statute. That seemed to me to be something that as probably the person who is on the court really is aspires to be considered the textualist heir to Justice Scalia, and in my mind proved his bona fides with this decision that wasn't going to happen. So I did have a bit of a confidence in that he was going to come through in a way that a lot of other people didn't. So.
Well, and that question almost sounds up. Sometimes the justices like to elicit answers because they're anticipating what the dissent might be or something along those lines. And that almost sounds like that he was trying to draw that out because he was trying to perhaps guess what some of the dissent might be if this did come down favorably for the employees.
That's certainly that's a very good point, and my heart kind of went out to David Cole, who was the lawyer representing Amy Stevens, who was at the podium at the time the question was asked, because there were so many responses to it, and I'm sure one of his initial gut reactions was, "I can't believe you're asking me that," but obviously he kept his composure. He talked about how none of the state statutes that had specifically prescribed these kind of discrimination had led to any of those bad effects. There were so many other answers to that, and of course, and sure enough, as is often the case when you have Justices Breyer, Sotomayor, Ginsburg, and Kagan, they are going to respond to their more conservative colleagues in a way that is that directly addresses what they said, maybe without actually indicating that. Because Justice Breyer started questioning, his question to the next lawyer who posed was along the lines of, "You're saying that if we rule this way, it means this, but it doesn't mean that at all. I'm only ruling in this case about whether these three people were fired because of their sex. Whatever happens after that is just what that's another day. That's another case. It was just fascinating to see that happen. And it was, there wasn't anything about Justice Breyer's question that referenced what Justice Gorsuch said, but it was absolutely the answer to that. And maybe Justice Gorsuch didn't need the answer to that. Maybe he was just asking the question but it was an amazingly effective rejoinder to that without ever actually calling it out and as a rejoinder itself. So
yeah. So what does it say to you that Justice Gorsuch was the author of this opinion? Does that provide any insights?
Well, let's just say that there were a lot of people who I think who it's apparent didn't believe him when he said he would follow the text of the statute, and that it includes basically the conservatives, the people who were social conservatives who were thrilled about his appointment and assumed that he would rule however they wanted, and that this whole thing about textualism, which they really didn't understand or believe in, was just a smokescreen for that. Yes, I will rule in your favor. And then a lot of people on my side of the aisle took their cues accordingly and said and didn't believe him because the people who knew him better. And this time, and he said, "You know what? I meant what I said, and I meant that." And what was especially, I thought, one of the best parts of it was that he talked about Title VII in a way that it hasn't been talked about before as this, but both in this context, both as a momentous piece of legislation that was supposed to change our fundamental way of thinking about these things, so that that aspired to a world that was absolutely, that wasn't necessarily the world that was right in front of everybody. So it was in 1964, right in the middle of the Mad Men era, that this decision comes down talking about sex discrimination, and the incongruity between those two things. If you allowed yourself to say it's only what, look at the time and look at what actually happened, in the years thereafter, then Title VII would mean nothing. But if you actually pay attention to the words, you would know that this is one of those moments where sometimes your reach exceeds your grasp, and that the fact that the world didn't change, and that people didn't. That the reality didn't match the words right immediately thereafter doesn't mean the words don't mean what they say they do. And it was, so I just thought it was really masterful in that sense of it, because this whole idea that the people said they couldn't have imagined what they were doing. Well, actually, there was a whole bunch of things that right after that didn't resonate with a lot of lower judges, but they eventually came to pass and in fulfillment of the actual meaning of the words that Congress passed.
Yep. Did it surprise you that Chief Justice Roberts also joined in this opinion?
Yes, yes. In the sense that he was good. He was more likely than some of them, but yeah. First and remember that the frame of reference was Obergefell, where he articulated perfectly, I would say, the sex discrimination argument during oral argument, which, basically he asked the question, I can't remember the names he used, but basically he said, if Bill wants to marry Steve and Sarah wants to marry Steve, Sarah gets to it, but Bill doesn't, isn't that just sex discrimination? And I think I hurt myself with uncorking the champagne bottle at that time, because I thought we had to, I go, this is fantastic. And then it became the only dissent that he's ever read from the bench, which usually is an indication of how vociferously a justice disagrees with the ruling. So yes, and I would say, what we came to find out with the last week was that he apparently he agreed with what he was saying there, as far as this is a difference in treatment based on sex, but under the Constitution you get to justify some differences in treatment based on sex, and that you have to meet a high standard, but apparently he thought it was met there. In Title VII, you don't get to justify differential treatment based on sex unless it's what they call a bona fide occupational qualification. So his rulings are actually consistent, and now we see the reason why, in a way that wasn't necessarily apparent, but that's and we, I would also say that we made a specific pitch to him along those lines in the amicus brief we filed by citing his dissent in Obergefell, which probably not a lot of other people who filed friends of court briefs on the side of the employees did, but I mean, which was basically to say that there's a way that that your ruling there and your ruling in favor of us here it works, and hey, it paid off. I can't say that I thought that was going to be a likely result, but I don't even know whether or not he read that, but it's one of those things where it can't hurt, and that is actually the way he ruled. So that it was a good day for us.
Yeah, I did think that was, so I read your amicus as well in my preparation for today, and I was like, well, that was an interesting tactic. I understood the relevance behind it, but I was like, oh, I don't know that many people would be citing a dissent in this.
Well, of course, and I will point out, it also had the benefit, because one of the things in the opinions that we were critiquing that were against coverage was some of the judges who didn't like her position in the circuit courts had said that Obergefell and a lot of other Supreme Court cases represented a rejection of the argument that sexual orientation discrimination is sex discrimination, because the tiers of scrutiny are are carefully applied in certain ways, and this shows that they rejected that. And if you know anything about Justice Kennedy, any attempt to say that he's carefully following the tiers of scrutiny and rejecting one over the other is going to be, well, basically laughed at by Supreme Court justices and anyone who follows the court. So this was an easy call, because at worst we were going to point out that any judge who would describe Justice Kennedy's rulings, and of course they're all written by Justice Kennedy in our favor, as being based on the tiers of scrutiny, that we were only going to benefit by pointing out that the problems inherent in anyone's analysis that actually would include something like that in their opinion. So.
Do you think we can read, so having, I know we talked about Justice Gorsuch's opinion had a very textualist vantage point, and we just talked through Chief Justice Roberts, how he joined this. Do you think you could read into this or extrapolate this, that there, I don't know if it's a shift in, I'll call it the culture wars, or, is there something that there may be additional paths forward depending on how people are presenting their arguments, that more conservatives could seem to get on board with what would be considered a more progressive agenda?
Well, I would say yes, but only to a limited point of the same sort of scenario that we saw here, which is, if you're pointing to a law that was broad in its scope, and you're arguing that it should correspondingly be interpreted broadly, and you're actually basing it on, and you have a good argument about why the words of the statute, even if people didn't connect all the dots at the time, are in accord with the result that you're urging. Yes, absolutely. Now, but I would also say that we're not fooled that when the argument comes about, like, for instance, religious exemptions, which was, at the end of this, I mean, that's a very different question, and we'll see how that all plays out then. I mean, this is a response to a very direct question, and along the lines of the wording that you said. I mean, I think about Justice Jackson's incredibly powerful wording and evocative of some of the most fundamental principles of our democracy and everything like that. And I kept telling people, and a lot of Justice Kennedy's decisions on LGBT rights kind of also had a soaring rhetoric and everything like that. And I was telling people, wait for the decision came down. This won't be anything like that. And this, I mean, because the court's wasn't asked to talk about the, how awful discrimination was, how unthinkable it is in this day that we would compromise these resources that are available and not give people the dignity that they deserve in the workplace. They were asked to say whether or not this was sex discrimination, and so they're happy. So people may have left, may have finished reading it, feeling less fulfilled and less, validated. But this was a huge ruling, and I think, and I think a lot of people recognize that. Just going about things through a different way that than has been the course with the constitutional cases that preceded it.
Yep, I noticed Justice Gorsuch was very succinct. He was very unambiguous. He was very crisp in his language, which you wanted to. It seemed to leave no room for ambiguity, and this carried through really to through the whole textualist argument, and even towards the end where he said, "I know people are going to wonder what about the religious exemptions and things like that," and he specifically said, to his textualist credit, that's not this case. This case is what we're looking at here, and we will take a look at that if and when it arises to us. So,
which is the same way that he answered his own question about, like, what other consequences are there. None of those are present in this case, and so we should wait until we have a case that that's argued and is front and center before we opine on that. I mean, I would say also that it was interesting how the extent to which, basically it's almost as though the dissent had wrote what they were going to write before they ever even saw what Justice Gorsuch said, which was, accuse them of legislation, accuse them of trying to update the law to comport with today's social values, which are have a more favorable view of the LGBT community. And of course, when you read a decision, like, there's nothing in there that suggests that that's what he was doing. But it's like, that's my story and I'm sticking to it. I mean, I thought that was painfully evident that it's like, well, that was going to be the label and the attack on whatever favorable opinion was going to be reached, no matter how divergent from the actual content of that opinion it was. So.
Well, and so that being said, naturally, a lot of news outlets and various other interest groups have been speculating in the last week or so as to what might the broader implications of this ruling be. And so any thoughts on that?
Well, and that's an especially great question, because I have to confess that I saw the benefit of a ruling in our favor across the board as being primarily limited to what the specific question was, which is about Title VII's coverage, and of course the employment protections that would then become nationwide, which, as you said, pointed out, are only in a minority of states in their explicit statutes. So that so that was my kind of working assumption going in, and most people's. And then the last business day before the decision came down, the Trump administration comes up with their transgender people aren't covered under the Affordable Care Act's non-discrimination provision, and it's like, lo and behold, there was all of a sudden a very concrete way in which the ruling was going to have a very big impact, I hope and think, in the blue states that already had. I mean, basically, because the Affordable Care Act ties its non-discrimination protections to it on sex to Title IX, and Title IX, I mean, it says on the basis of sex, is you can't there can't be discrimination in the provision of healthcare. So after last Monday's ruling, the Trump administration's attempted rollback of the protections under the Affordable Care Act looked really as though they're prone to attack, which is why Lambda Legal filed a lawsuit this week attacking and doing just that. And so the idea that it would be able to be used so quickly in such a way, it's sort of it was kind of remarkable. And but it's with in the times we live in now, you just never know.
It's true. Yeah. So, and I thought reading your brief and some of the other briefs too, what struck me really was how this was being portrayed as the progression in the next step in civil rights. And so it was really drawing the parallels between, okay, we've talked about discrimination against people of color and women for eons, it feels like. And now this is sort of I don't necessarily mean next step, but it's like, okay, now that we have these groups protected, we need to continue this civil rights push. So what does this provide any insight on how the court might look at additional civil rights cases going forward?
Well, it does, and your and the point here, which is very interesting. Is that and this is part of the sort of, I would say, unique history and treatment of Title VII that's very important to keep in mind about this, which is that normally, trying to do an easy analogy between certain kinds of discrimination and other kinds of discrimination is, it's kind of fraught with all kinds of problems. Title VII is, first off, that nothing about the arguments has as a basis that discrimination that the lesbian, gay, that the LGBT community faces is very, very similar to what women have faced throughout the ages. There is, you can, because it's well recognized that as recently as 1947, you had the Supreme Court saying, oh, Michigan can absolutely forbid every woman from being a bartender, and you're going, without question, and you're going like, really? And so there is an appreciation. Anyone who thinks that this was this is just like race or just like discrimination that women have faced, it wasn't. And Title VII, because Title VII asks a different question, which is that it's just whether or not you don't have to compare the magnitude and the contemptibility of the discrimination in order to establish that this is covered by Title VII. First off, that should be obvious with just looking at the text of the statute, which, as bad as national origin discrimination may be, I don't think there's hardly anyone who thinks that the history of that resembles the history of race discrimination in the United States. And yet there they are side by side in the same statute. And which the courts have actually said that the treatment by the statute of the five categories, five traits, in the same way means that we will generally try to treat the rules about what constitutes discrimination under the statute the same way, which is not at all to say that the racial discrimination is the same thing as national origin discrimination or religious discrimination, but it's just to say that as far as what counts as qualifying, then we will try to apply the same rules, even though the history is very different. So I think and this especially became important with the interracial relationship analogy, which was for which the only response was to try to talk about how much worse that kind of discrimination was, which is absolutely true, but it obscured what the actual argument was, because nothing about qualifying under the statute depends on how awful the discrimination was. So it's something that we that we take seriously, as far as because frankly in the past there have been times when people have said have fallen into the just like race category or just like discrimination against women category, and without sensitivity to like the differences and everything like that. And nothing about our arguments here depended on that kind of argument, even though it was cast by the other side as being just that. And that was part of the problem. So I just think that that's an important framework for people to have when they think when they read this, especially because there was no rebuttal to the regarding the interracial relationships in the majority opinion, even though Alito talked about it in his dissent. So
yeah. No, absolutely. So let's talk a little bit too what this means at the state level. So we went from 23 states having some explicit protections, and now and some, like California, very robust. And then you have the 27 states without any explicit protection. So what are the practical impacts of this? Yeah,
very good question. Well, one thing that people should know is that probably the biggest difference between state statutes and Title VII is that Title VII across the board has a 15 employee minimum requirement before it applies. So whereas most state statutes an awful lot of them have a lower threshold. So to the extent that your state has explicit protections on sexual orientation or gender identity and a lower limit, or even just has sex discrimination prohibition that might now be argued to cover it, the lower threshold for the number of employees could be a big deal. There also, as far as remedies, usually Title VII is considered, whether the gold standard, but that's one reason why access to Title VII has always been considered so important. But some states, themselves have pretty good remedies. And what'll be interesting, of course, is to see whether in the coming years, whether the federal courts are as hospitable a forum for resolving non-discrimination claims as state courts are. And part of the some of the news in the news this week that there have been 200 federal judges appointed by Trump that have been confirmed, including all 53 vacancies that were present in the Court of Appeals at the circuit court level when he took office, and it occurred since then. But there are currently 0 vacancies at the Court of Appeals. That is a remarkable phenomenon, and shows you the extent to which the U.S. Senate has had no other purpose for the past 3.5 years. But at least you got to tip your cap to them. Their handiwork has had big time results, and it'll be interesting to see how that plays out over the upcoming years as far as a choice of forum by employees who experience discrimination.
Yeah, no, well, and so in addition to the choice of forum, there is the Equality Act as well. And so why don't we talk a little bit about that, because I think one of the sort of main critiques, I would say, of Justice Alito's dissent was that he sort of felt Justice Gorsuch was legislating this, and that if you really wanted change, that wasn't the court's job, that was the Congress's job. So let's talk about the Equality Act.
Well, and a couple things on that point, and I think back to I mentioned the Michigan bartender case. Well, that case was overruled in 1976 by a case called Craig versus Bourne, there were several cases in the 70s that in which the Supreme Court came around and to say the Equal Protection Clause, which applies to women and applies to sex discrimination. That happened at the exact same time that the Equal Rights Amendment was a huge deal. So and the Equal Rights Amendment had first been introduced in 1923. So by pursuing the Equal Rights Amendment, that didn't mean that women weren't covered by the Equal Protection Clause of the 14th Amendment. So, they sought a very specific and separate and unequivocal pronouncement of equal protection. But that didn't mean that they, like everybody else, that you didn't have to ask the question, what about does existing law cover us? And and the fact that the Supreme Court had basically said the Equal Protection Clause is meaningless for women, as recently in the 1940s, didn't prevent them from doing the right thing in the 1970s. So, some of the arguments about like how the existence and invoking and trying to introduce amendments to get a specific coverage, that's true. That all happened. It happened just like it happened with women in the. But none of that changes the real question for the court, which is look at the existing law and does this fall within the terms of the existing law? And that's how women managed to make such huge strides forward with the Supreme Court rulings in the 70s, and was what happened a week ago Monday too. So, but as for the Equality Act, a lot of people might be thinking like, well, now we don't have to worry about that. That is not true, because what happened a week ago Monday was that everywhere that the sex discrimination that the federal law says sex discrimination is prohibited, that we certainly will argue. I suspect well, first off, we know the Trump administration will obviously have a different view, but that applies across the board whenever the federal law prohibits sex discrimination. But even if we were to win that argument completely, there are still areas where sex discrimination is not prohibited under federal law, most notably in public accommodations, also in like federal funding. So there is a basic need for the Equality Act, which I think a lot of people would welcome the fact that you don't want to have different rules about credit and housing and education, and it's very, very helpful just to have an across the board rule about you can do this, you can't do that. The Equality Act does that. It also remedies the fact that the public accommodations provision in Title II of the Civil Rights Act of '64 is like very inadequate and doesn't match what anyone's definition of public accommodations would be today. For instance, retail stores. Right? People go like, retail stores are not a public accommodation. No, they're not under Title II of the Civil Rights Act of '64. So by adding sex discrimination into that, and then by expanding the list of what constitutes a public accommodation to what everybody would assume it does mean today, that actually lifts the boats of everyone who's covered by the Civil Rights Act. So the Equality Act is still very important. Quite frankly, it should be an easy lift now. I mean, now after the Bostic ruling, it should be like, let's just get this done now that Bostic did most of the heavy lifting, but there's still important stuff that has to be done. And hopefully it'll actually be a situation whereas instead of removing the urgency for it, it becomes more of a, okay, let's just do this. Let's stop fighting, let's stop fighting modern, modern notions of fairness. That's what we hope.
Yeah. So, and this is something, so 5 years ago, shortly after Obergefell, I was having a conversation with a couple of friends, and they said that their greatest fear after that decision was people would think, okay, we've achieved gay marriage, we're good, we're done, we can all go about our lives and go back to things again. And honestly, that was the first time that had ever occurred to me, because I did fall into the camp of like, okay, there's this, and not really recognizing still the vast differences between how homosexual and transgender people have what they have access to and how they're treated compared to cisgendered. And so I feel as if this may yet run another risk of, okay, we've achieved this, and so maybe now we're good and we can go focus on something else.
Well, and that's why I welcomed all the emails from all the people involved in reproductive justice who said, "Oh, be sure to rest on your laurels now, just like we did." Let's just I won't characterize it as good, or I'll just say that it is what it is, and we know it is that the people who oppose and oppose this in this case, they have a tendency to view Supreme Court opinions as an opening offer as opposed to the law of the land. So in other words, like, okay, that's just another obstacle that we have to overcome we're under no delusion, and it's another example of how we've learned and followed from civil rights movements before us, which is that yes, just when you think that you've got a big win, that's when the other side redoubles its efforts, and obviously one of the goals is to convert the non-discrimination commands of the law from to suggestions if someone has an objection to complying with them. And so it's once you close one door, another one opens, and we are trying to do what everyone would advise us to, who's been down this road before, of don't get complacent and don't think and don't roll out that mission accomplished hammock just yet. So.
And then how do you keep momentum on your side as well, like with your supporters, and so that they don't also run the risk of thinking, oh, okay, we've gotten this far, we're good.
That is, I should knock on wood, because I mean, part of it is that what I just said, doesn't come as much a surprise to, like, our supporters who I mean, and I have to tell you that who they have been they're always anticipating the next thing, I guess I would say, so much so that I found myself a couple of times over the past few years, especially if they were in some of the blue states that already had protections, and who they already saw I mean, ever since Hobby Lobby came down, which is now 6 years ago, saw the looming threat that might have to enforcement of non-discrimination laws. And I had to remind them that, hey, not everybody has non-discrimination protections at the moment that are recognized by the courts. So I mean, this is one area where I would say a lot of the people who support us are always way ahead and always anticipating the next thing, sometimes even before we've won the battle in front of us. So which is good, but that's one problem that I don't think we have to worry about too much. So.
That's great. Okay. I want to turn back to the opinion itself. And so, you mentioned that Justice Gorsuch sees himself as the heir to Scalia's textualist approach. So how would you, I guess, sort of put this opinion in the historical landscape of that?
Well, I would say, and I don't think it's a coincidence that I would say that if you're in textualism history, the two biggest decisions should be, or the two high watermarks should be considered on-call and Bostic. I mean, on-call was, so this is a 1998 opinion that Scalia wrote for a unanimous court, and this had then settled a debate that was roiling the lower courts, which was, do you interpret Title VII according to the reasons that motivated it, or do you just pay attention to the cold words on the page? And there was an opinion that a federal judge in Chicago wrote that was the lead argument for why you actually, it was basically the anti-subordination aspect of Title VII. In other words, like we could this is about whether men who were sexually harassed by men had a claim under Title VII, but it was very apparent that women who were sexually harassed by men did. So it was pretty much apparent to everybody that in 1964, nobody was thinking about male-on-male sexual harassment as any sort of social problem that was going to be cured by that law. But the question is a man who was singled out for sexual harassment because, at least in part because of his being male, does he have a claim under Title VII? And and nothing about the goals that animated the passage of Title VII supports that claim, as was laid out in great detail by Ann Claire Williams, who was then on the Northern District of Illinois. But what Scalia said is that no, none of that matters. If this wouldn't have happened to him if he weren't a man, that he has a claim, and yeah, this doesn't really align with the goals of Title VII or the people who pass, or the mindset of the people who passed it. But this is what's alleged here is discrimination because of sex, and that's all that matters. And I just point out that Judge Ann Claire Williams was subsequently elevated to the Seventh Circuit, and she ruled in our favor in Hively, which is exactly. I mean, she wrote an eloquent decision that was perfect to articulate the argument about why the anti-textualists look at the goals that animated it. And when the Supreme Court said no, that's not the way we roll anymore, she goes like, good, and she recognized our argument, so and voted in our favor for the Seventh Circuit. So which is a perfect example of that's what lower court judges do, and if they're doing their job correctly. So but so this is I think these two decisions will be regarded as the high watermarks, which I think is important because the sex discrimination provision of Title VII is, I think, the classic example of a law that was that when it was passed, people didn't really appreciate the full implications of what they're doing, but they passed the words, and and of course, as a lot of people know, it was a late in the game amendment to a law that was otherwise going to be passing forbidding discrimination because of race and national origin, and I can't remember the color certainly, and maybe religion was already there. But basically, what was existing there was a law that said no, this discrimination is never okay, because it's hard to really justify discrimination based on race that ever is going to be, or distinctions in treatment that are ever going to be okay. Whereas when it came to putting sex in that, it raised the question of whether, what about all the times we might treat men and women differently, and are all of them forbidden? And the court basically, in what they actually did, was that they made a small change, which was to say that there's a bona fide occupational qualification exception, which allows for a very, very few differences in treatment based on sex, but that does not apply to race. But otherwise, they pretty much kept the exact same law that they had before, which said you just can't do this. And then they passed it. Now they may have done that because back in those days, Congress actually did things. They actually, if there was a problem with it, they passed it, came back the next year and did something more about it. And now there's this very fatalistic kind of thing. Well, if you ever get to a moment where Congress actually passes anything, well, that'll never happen again. And so it was. But I think and this is one thing that Justice Gorsuch did in his opinion. He explained that history, and that history used to be cited as a way of justifying treating, of validating differential treatment of men and women, meaning that this amendment had taken them all by surprise and really put them between a rock and a hard place. And shouldn't we acknowledge that and think that, well, they didn't understand all the ramifications of what they did. That is a very anti-textualist way of doing things. So when you actually look at what they did, they basically said, they made some changes and then said, no, we're good here. We're gonna basically say you can't treat men and women differently. And so, which means that those people who want to justify those differences in treatment have to go back to Congress to do it, which is exactly the way a textualist would have it. It's like you don't get to say like, well, they didn't think about it because they only had a couple of days, so we're just going to go and write in all these things that they probably didn't realize they were actually greenlighting at the time. No, that's not the way to do it. The way you show respect for Congress by honoring the words that it passed, and you don't get to play around and guess about, oh, they wouldn't have done this if they had known. That's not the way of doing things. So I think the two opinions together should be considered, and hopefully will one day be considered the bases on which textualism is understood, and and what has historically been viewed as a very conservative doctrine. It's like, well, if you're really holding up a mirror to what Congress did, then it's not really conservative or liberal. It's just doing what Congress said, which can be very broad or maybe narrow, but it depends on what the statute actually says. And that seems to make a lot of sense.
Well, then that gets into Justice Kavanaugh in his dissent mentions that the justices and judges are bound by the ordinary meaning of text, which seems, from obviously the way he wrote it in his mind, to have some different than how Justice Gorsuch analyzed this.
Yeah, and well, first of all, the one question that he asked in oral argument was along those lines. I was baffled by that question then, and I remain baffled by it now, in the sense that, what Justice Gorsuch said in an opinion from a couple of years ago was that you should just apply the words of the statute. And the only reason why you wouldn't do that is if the definition of a word or meaning of a word or phrase had changed from 1964. Well, there was from the get-go, there was always a very considered judgment not to question the notion that sex meant a man versus a woman. And now you could argue that sex, that's way too narrow a definition, but for the purposes of litigating this case, it was always smart just to accept that as the meaning that it had back then. And then go from there, because if you did that, then you would then it actually helped your case, because it certainly, if like the sex, people basically assume that, well, the sex that was marked down on your birth certificate when you came out, in the maternity ward is your sex. That's a very conservative notion that a lot of people might find very problematic now, but by embracing it as the mindset in 1964, it allows you to say that there's differential treatment based on someone. If someone's presenting as a woman now, and you have a problem with it because there was an M on their birth certificate way back then you obviously have a sex discrimination claim. And so, and same way with, if you choose to marry somebody, and if you have a husband, whether or not that's legitimate depends on your sex. That is an easy argument to win. So by embracing the definition that people had, the mindset that people had at the time, then which does not mean that is what the actual answer to the question is of what sex is. It's a win-win situation. And there was a case that very important case at the beginning of 2019, where a unanimous court, Justice Gorsuch writing, said that contracts of employment today absolutely exclude independent contractors. Every lawyer agrees that, nobody argued that, but the independent contractors won the case by arguing in 1925 that wasn't what people thought. We weren't excluded from that definition in 1925. And Justice Gorsuch said, you're right. And so this idea that like sexual orientation discrimination is excluded from the definition of differential treatment based on sex, that's all. If that, to the extent that's true, it's all because of things that happened way after 1964, like in Stonewall and the American Psychological Association delisting of homosexuality from the list of disorders in 1973. That gave birth to people thinking of sexual orientation as a separate trait and sexual orientation discrimination as a separate phenomenon. None of that was true in 1964. So this was an example of, just following the doctrines and I mean, that the court had previously said, and having the better of the argument.
Yep. All right, we're going to pause for questions right now. So I am Kristan McMahon, the president of the Robert H. Jackson Center, and I am talking with Greg Nevins, the senior counsel and director of Lambda Legal's Employment Fairness Project. If you have questions, let us know. Greg, do you actually have tea in your mug, or do you have something else?
Well, I'm not a tea drinker, but I am a ginger ale drinker. So
very nice. Perfect. Yes. I went with I think it's Sydney breakfast tea this morning. I was feeling Australian, I guess. I'm not quite sure. So, all right, we have a question from Helena. And so Helena's question is, what is the distinction, and it's probably a distinction with a difference, between the effect of sex-specific dress codes? So employees who are fired for violating sex-specific dress codes versus, and I think she's probably thinking of Amy Stevens in this case. So if you are transgender and you are dressing with your identified gender, are there ramifications here? Is this a fairly easy call given this case?
Well, I think it's important now to mention Amy Stevens and rest in peace, because as unfortunately tragically she missed by she passed away a month before the decision came down, and didn't get to see the wonderful achievement that she accomplished here. But so when and a lot of people have talked about how dress codes are inherently sex stereotyping and the like. And what was interesting in Amy Stevens' case is that, and that may be true, but Amy Stevens didn't have any problem. She goes like, the dress code has been fine with me so far, and it remains fine with me. I'm going to be presenting as a woman, and your dress code for women, I'm going to abide by that. Now, that doesn't mean that that's legitimate under the law, but nobody was questioning it. So, I mean, this was one where the employer and the employee were, she was willing to abide by the employer dress code, but the employer said, well, no, you're not a woman, so you don't get to do that. So I just want to say that sometimes there are things where the employer and the employee are just in agreement with it, which doesn't mean that, that the law would say it's okay if there was a challenge to it, but there's no challenge to it. So there's that. I would also say that, in the history of treatment of dress codes and hair length is now, I mean, yes, if you go back and look at the case law on that, it is very hard to justify some of those things. And back in the day, so the court had ruled in 1971 in a case that turned out to have a huge impact on the decision 10 days ago, that you can't have one hiring policy for men and another for women who each have young children. That was the Phillips versus Martin Marietta case that said that because Martin Marietta was great about hiring women, but except when they had small children, in which case they were either ineligible for hiring or they got sent home. They got a pink slip. And so the Fifth Circuit, in one of many questionable opinions, it's written on Title VII, said that was okay. And the Supreme Court unanimously smacked that down and said that you can't have one hiring policy for men and another for women. And so then came the question of, well, what about having different rules for men and women about hair length, or having different rules for men and women about dress? And the circuit courts turned themselves into pretzels, coming up with a way that they could articulate why that would be okay, but not in violation of the Phillips versus Martin Marietta precedent. And they arrived at at very questionable distinctions about that, and those will have to be looked at to see whether they hold any water after this decision. And they probably don't. I will also point out that you didn't have to overrule any of the hair length or dress code cases in order to rule in favor of the sexual orientation part of the case, for sure, because one of the distinctions that was drawn was that if there's a constitutional, what happened in Phillips versus Martin Marietta is that it was about the small children, and of course people have a constitutional right to rear children. Well, now you have a constitutional right to have a wife if you're a woman, or a husband if you're a man. So that distinction would go by the wayside, and it shows that. So I would say, I would not, if I were an employer, I would not put any effort into trying to enforce a gender-specific dress code, because you might live to regret it in court. So.
Gotcha. We had a question mailed in ahead of our talk as well. And Shannon was asking about the role of legislative intent. So now going forward, certainly you touched on that a little bit, of going back and seeing the fact that they couldn't possibly imagine the ramifications of this or how it might be interpreted in the future. But what role is there for legislative intent in analysis?
Not much. I mean, honestly, I mean that's the fundamental threshold question here. I mean, we proceeded under the assumption that nobody in 1964 thought this would thought the law that was just passed would prescribe sexual orientation discrimination or gender identity discrimination, and they might very well have said, what do those terms mean at the time. I think that, but I do think that one thing that should be kept in mind is that the opinions, really all three of them, never really talk about why somebody in 1964 would have had that belief. They don't really drill down on that, and I think that's unfortunate, because what I suspect is that somebody would say, something like, well, I mean, if you take the argument as it was articulated, which is, that if Bill can marry Sue, then but Sandra can't marry Sue, that it's sex discrimination. If you took that argument back to 1964, the approach would be, you show me the day when a woman can marry a woman or a man can marry a man, and then I'll agree that this is sex discrimination. That's what probably people would have said, and that would have been legitimate in a world where 49 out of the 50 states still have their sodomy laws on the book, and marriage between people of the same sex was a very distant gleam in people's eyes, if any. And that is one very established rule that everyone agrees on, which is that if the meaning of the words haven't changed, but something outside that particular context has made what was then unthinkable now the obvious result, then you go with the obvious result. I mean, I think that's what captures a lot of people's real mindset back in 1964, which is that, until you're talking apples and apples, this isn't sex discrimination. Now we're talking apples and apples.
Gotcha. All right. Well, I am not seeing any more questions at the moment. We'll just pause for a moment to see if anybody has thought of anything else. Greg, there are certainly, obviously, a lot of people interested in this and also interested in understanding how they can help move things forward, how they can get involved. Do you have any recommendations or guidance for people who want to help in some way?
Well, I certainly would, I don't know whether it's bad form to say go to lambdalegal.org and hit the donate button, but certainly I would, our work on this is ongoing, as I've described, and any support we could get would be helpful. Also, definitely please support passing the Equality Act, and tell your, I guess at this point, senator. Although this could be something that passes easily next year. It'd be why not pass it this year? I mean, it would be. If there was an outpouring support for that, that would be a great thing. Be involved, keep attuned. I mean, it has been very uplifting to see that a lot of people were paying attention to this case. A lot of people celebrated it, and I think. But what I would ask is, there are. Now we're in the, we established something very foundational and very of a huge breakthrough. Now comes the time when we have to make sure that actually is a live reality for people, that we don't get to a point where, okay, so you want something on paper, but it doesn't actually translate. And a lot of other movements appreciate that very well. I mean, you think about, in this country, permissible differentiation in the law based on race has been anathema to in every court for decades now. So you should have had, from the formal legal perspective, problem solved. I think especially now there is the extent to which the gap between the formal law and live reality is being appreciated in a way that is that's really profound and is long overdue. So and that we'll, and even though our situation is very different, but that same general rule that you accomplish the literal equality, but you actually don't get any sort of actual equality or equity, is something that we're going to try to make sure doesn't happen again. And we're so. And there are, so this is just at the highest level of generality, just to learn an important lesson that other people have, that a lot of other groups have faced in the most real and difficult way. And so hopefully we're coming to a point where we're getting past those things, and people are trying to make sure that everyone, that it's not just words on a page, but that people's lived reality and lived equality is part of the fabric of American life. I think and so that would be the message going forward, I would say.
Thank you. I think that is a great note to end on. Certainly, we are seeing some of the starkness between the law on paper and the law in practice. And we all need to be vigilant about that. So, Greg, thank you so much for being with us this week.
Thank you for having me.
And thank you to our audience as well. Next week, we will be speaking with Jeff Howe, who is the Executive Director and Chief Investigative Counsel for the Global Accountability Network. So I look forward to seeing all of you next week. And Greg, thank you so much for being with us.
It's great. It's been great to be with you. Thanks so much for having me.
Thank you.